Mention.
I beg to mention item 20, my lord, that bonded warehouse matter. There's some orders that have been passed in the policy matter before the division bench. This matter can be deferred for another 2 weeks.
Deferred or closed?
Not closed, my lord.
It's a tender matter, this one.
This is tender, my lord. There's some directions for reconsideration of the policy.
The government is still examining the...
Who's examining it?
The government.
Yes, after 3 weeks, yes.
Indeed.
As there are certain policy decisions that have been made in the instant matter by the respondents. Yes.
Indeed.
Lordship, I'd like to mention item number 28.
28.
I've taken consent, Your Lordship.
You're for whom?
And for the
Respondents?
respondent.
2 weeks, yes. That's it.
Lordship, I beg to mention item number 15.
What is this? You're for the?
I'm for Joy Municipal Board.
No objection, Your Lordship.
2 weeks, yes. You're there also?
Lordship, 16 also, Lordship.
You have objection, Mr. Chanda? No. Yes, 2 weeks, yes.
Obliged.
My lord, this item number 21, where I have raised a question whether the rules of the game can be changed once played. Now, the Supreme Court in the...
Which one, 21? Pringle Marak?
Pringle Marak, my lord. Supreme Court in the constitutional bench has reserved this issue, my lord. My lord, if...
Rules of the game can be changed when?
After the game started, my lord. Yes. Exactly in this issue, I have raised that question, my lord.
What was the matter about?
This was a selection of DSC, my lord, where the typing speed, the criteria for the typing speed was scaled down after advertisement and after...
Okay, after when? After 2 weeks?
2 weeks, my lord.
Okay, 2 weeks, yes.
Obliged.
On the prayer of the constitution. Yes.
Your Lordship, I beg to mention item number 17, Your Lordship. I pray that the matter may come up after 3 weeks. The conducting
3
council
weeks?
is on sanction date.
He's on the handle for 3 weeks.
Your Lordship, 2 weeks may be given then.
2 weeks, yes. You're there also?
May I please, Your Lordship, I beg to mention item number 18, Your Lordship. As Mr. S. Day, grandmother is in ICU, so we...
What is an ICU?
Yes.
2 weeks, yes.
Lordship, I beg to mention item 25. Covering for 1 week time since the conducting council is out of station.
20?
25.
Senior counsel is not here today.
It's out of station, Your Lordship. No objection, ma'am.
2 weeks, yes.
Obliged.
That's it. For now.
Supplementary list, item number 1.
May it please, Your Lordship, I humbly pray if this matter may come at the end of the vote, my lord.
Oh, this is a suspension matter, my lord, wherein the Lingdor court has been suspended pending inquiry, my lord.
He is?
He has been suspended.
Right?
As a Lingdor.
Yes.
And the same is pending inquiry, my lord.
No. Is this a matter regarding suspension of Lingdo or what?
Lingdor court, my lord, of the Laikpo, Maukarda, Laikantai, Nobus Opposition, my lord.
Does it have a specific act governing this impship, no support? Is there any act?
There is no specific.
It's governed 59.
It's governed by the 859, my lord.
After some time, yes. Next matter.
Item number 2.
Yes, Mr. Nath.
May I please, Your Lordship, this is a matter in regard to the tender, my lord. Here, my lord, a tender was floated and accordingly work order was allotted, my lord. After work order, my lord, I have completed the work.
What work is this?
Well, it is in Nehu. In Nehu, my lord, work was...
What kind of work? Civil works?
Repairing works, my lord.
Okay.
All allotted works were completed, my lord. After completion, the work certificate was also issued, but the department is not preparing a final bill, nor they are asking taking any step.
When did you finish your work? When did you start?
When
did you submit your bill?
I am not allowed to submit the bill. They said they will.
When did you complete the contract?
I have completed in July 22, my lord.
July 22.
Yes, my lord.
So over a year now. Where's Mr. Sen?
Almost here.
It's on leave, Your Lordship.
We listed on Monday. Have instructions.
No, Your Lordship, no instructions.
So are seeking time, or you have, or you just accept notice?
Yes, Your Lordship.
Then accept notice then. Yes, heard Mr. Janat, another counsellor with the petitioner. Issue notice returnable in 2 weeks. MSS Shalam is present. Vice Mr. SN is present and accept notice on behalf of all the respondents. No further notice called for. Let's up to 2 weeks for instructions or affidavit. Yes.
Obliged.
Obliged, yes.
Item number 3.
Lordship, we have already filed an affidavit bringing on record the correct copy of the first impugned order. Your Lordship,
First impugned order.
that is 15.3.
Okay.
23. In paragraph 21, there was some line which were missing. What has happened, Your Lordship, actually the court passed the order in the laptop. Then before it was taken on the order sheet, it was uploaded in the CIS. And thereafter, she asked her staff to take out the print and put it in the order sheet. Now, while taking the printout from the order sheet, that they have to adjust according to the margin.
It's all right.
So
maybe a different operating system.
So that
Yes.
order which is in uploaded, that is a correct order.
Okay.
Your Lordship, I have filed this as I have submitted on the last occasions. I have filed this 227 petition,
Yes.
wherein I have assailed 2 orders passed by the
Yes.
commercial court in an execution proceedings. That is the order dated 15/3/23 and the order dated 30/5/23.
Two orders are challenging. One is 15.3.
Other one is 30/5/2003.
23.
First order is at page 144.
Okay.
144.
Yes.
And the second order is
Dated.
at page 186.
Dated.
186.
The date.
30. 30/5/2023.
Okay. Yes.
Your Lordship, this petition raises 2 most pertinent questions. There are two dates, Your Lordship, which are important. The first date is that the award was passed on 5/6/2015.
5/6. Okay.
2015.
Yes.
And Section 34 petition was filed on 31/8/2015.
Okay.
And Arbitration Amendment Act 2015 came into force on 23/10/2015. So therefore,
That is undisputed position.
this is undisputed positions.
15. It came that amended act.
Yes, and which came into the force on 23/10/2015, meaning thereby that on the date of passing the award as well as on the date of filing Section 34 application, this amendment was not
Present.
there. And the proceedings which were to be gone, those are gone under Section 34 and 36 as it stood prior to the amendment of 2015. Prior to the 2015 amendment,
Yes.
according to Section 36, the moment you file the Section 34 application, and if it is filed within the time stipulated,
Automatic stay.
there is a automatic stay. And no formal application for stay was required.
Necessary.
23/10/2015, this amendment came into force. Now, there were confusions in many high courts, some high courts said that that 2015 Amendment Act will apply prospectively. Some said no, it will not apply prospectively. It may also apply retrospectively. Ultimately, Your Honor,
I think there's something with retrospectively to certain arbitrations that was still, there was a certain like rider to it.
Yes.
That's why the confusion arose.
Yes, Lordship. Now that confusion, Your Lordship, was clarified by the Supreme Court in Kochi Cricket Private Limited case, and that is 2018 6 SCC 287. If Your Lordship, I am permitted to take to Your Lordship that judgment.
Yes.
Your Lordship, we'll just see first paragraph 2, that what was the point in issue. The question raised in these appeals required the mentioning of only a few important dates. In 4 of these appeals, namely BCCI versus Kochi Cricket Private Limited, so and so, so and so, so and so. Section 34 application under the Arbitration Act, Conciliation Act 1996, hereinafter referred to as the 1996 Act, were all filed prior to the coming into the force of the Amendment Act with effect from 23/10/2000. That was one set of appeal which were filed prior to this amendment came into force. In the other 4 appeals, the Section 34 application were filed after the amendment came into force. The question with which we are confined is as to whether Section 36, which was substituted by the Amendment Act, would apply in its amended form or in its original form to the appeals in questions. So for Your Lordship, the application which were filed after 23/10/2015, there was no problem. That amendment will take care. But the problem was with regard to those applications which were filed prior to the amendment came into the force. Then Your Lordship may also see that they have taken the first set of the cases. The relevant facts of the first appeals, namely BCCI so and so, are as follow. A notice dated 18/1/2012 was sent by the respondent, 1, invoking arbitration under a franchise agreement so and so. A sole arbitrator was appointed who delivered the arbitral award dated 22/6/2015 against the appellant and in favor of the respondent. On 16/9/2015, the appellant filed an application under Section 34 of the 1996 Act in the Bombay High Court challenging the aforesaid arbitral award. So, Your Lordship, from paragraph 3, what we find that the first set of appeals.
No, they made a distinction, that's all.
Yes.
They made a clear distinction,
Yes.
those who are filed
Yes.
after the Act came to force and amended section and before that. Yes, continue.
Your Lordship will come to what the court has held at paragraph. I may just read paragraph 31 also.
Yes.
Paragraph 31. The law minister response to the aforesaid speeches stated that may not be, because these are the parliamentary debates. Lordship will come to state paragraph 39. What does the court has to say? Section 26 therefore bifurcates proceedings as has been stated above with a great degree of clarity into 2 sets of proceedings. Arbitral proceedings themselves and court proceedings in relation.
You're reading para 36?
39.
39.
39.
Yes.
Section 26 Amendment Act clarified.
Yes.
Okay, yes.
Section 26 therefore bifurcates proceedings as has been stated above with a great degree of clarity into 2 sets of proceedings. Arbitral proceedings themselves and court proceeding in relation thereto. The reason why the first section of part of section 26 is quoted in negative form is only to state that the Amendment Act will apply even to arbitral proceeding commenced before the amendment if parties otherwise agree. If the first part of section, if the parties other, it will apply, your Lordship will mark, the reason why the first part of section 26 is quoted in negative form is only to state that the Amendment Act will apply even to arbitral proceeding commenced before the amendment if the parties otherwise agree. Here we did not agree. If the first part of section 26 were quoted in positive language, it would have been necessary to, your Lordship may escape, come to the next, leaving 2-3 lines. What is the finding of the court? The scheme of section 26, Lordship got it? Yes. The scheme of section 26 is thus clear that the Amendment Act is prospective in nature and will apply to those arbitral proceedings that are commenced as understood by section 21 of the Principal Act on or after the Amendment Act, and to court proceedings which have commenced on or after the Amendment Act came into force. So, your Lordship, the apex court in this case has held that it will apply prospectively. Your Lordship will also notice another paragraph 75, and your Lordship will come to page 336 of the report, and yes. I read it. We do not express, Lordship got it, page 336 of the report.
Report? Yes, I found it. We don't express an opinion of aforesaid contention.
We do not express any opinion on the aforesaid contention since the amendment made to section 34 are not directly before us. It is enough to state that section 26 of the Amendment Act makes it clear that the Amendment Act as a whole is prospective in nature. Therefore, whether certain provisions are clarificatory, declarative procedure, and therefore retrospective, is a separate and independent inquiry. So, paragraph 39 and 75, the Lordship has held in this case that Amendment Act is prospective in nature.
Unless otherwise agreed to by the parties.
Yes, otherwise, if it is otherwise agreed by the parties, right. Your Lordship. Then this position of law was a settled principle of law. Then court attention was drawn to this judgment, that this is the settled principle of law. Court relied upon the judgment of HCC, which I take to your honor the impugned order 144. Page 144.
Yes.
Paragraph 9, your Lordship will see.
Yes.
In their show cause, the judgment debtor has contended that the impugned petition is filed by the petitioner for execution of the arbitral award dated 5th June 2015, passed by the arbitral tribunal under the provision of Order 21 Rule 11, read with so-and-so, is not maintainable, and the petition for execution itself is not in the proper form. The notice receiver judgment debtor submits that notice in terms of arbitration clause was received by the petitioner on 23rd March 2002, and thus the arbitration proceedings deems to have commenced with effect from 23rd March 2002. The award of the arbitral tribunal was made and published on 5/6/2015. The petition under Section 34 of the Arbitration and Conciliation Act 1996 was filed by the Notice Receiver Corporation on 31/8/2015. The notice to commence arbitration under Section 21 so-and-so Hence, it is submitted by the learned counsel that the provision of Section 36 of the Arbitration and Conciliation Act as it stood prior to its amendment in 2015 are applicable to the present proceeding, inasmuch as the instant execution petition for executing the award itself is not maintainable. And we have stated. Then your lordship will come that court has noted the Board of Cricket case. The petitioner during the pendency, next page your lordship, yes. The petitioner during the pendency of the petition under section 34 of the Act has also never approached this court for execution of the instant award since 2015. Your lordship will find that execution petition came after 7 years. Okay. 7 years of the passing of the award. The judgment debtor submits that the impugned award dated 5th June, which deems to have already stayed as per the provision of law prevailing in the relevant time, cannot now be executed during the pendency of section 34 petition filed by the judgment. The learned counsel for the notice receiver judgment debtor further submits that the Honorable Supreme Court in the case of Board of Control for Cricket versus Kochi Cricket Private Limited as referred. Then your lordship will see the court has quoted the para which I have. The court was not having SCC, court was having some other journal in which the same para 39 is para 15. The para 15. The scheme of section 26 of the Amendment Act is thus clear that the Amendment Act is prospective in nature. Then your lordship, the court has also taken note of that it is clear that as such amendment would only be prospective in nature. We do not express any opinion on the aforesaid contention since the amendment made to section 34 are not directly before us. It is enough to state that section 26 of the Amendment Act as a whole is prospective in nature. Then your lordship, they have referred to the case of Hindustan Constructions. Your lordship, paragraph 14, we have also stated that there are Niti Ayog guidelines by which the award holder can take 75% of the awarded amount and subject to the furnishing of the bank guarantee. They did not opt for that, and they say that money should be given without furnishing the bank guarantee, which was not agreed, your lordship.
What is the finding? Yes. Yes, please.
Then your lordship, we have also quoted in paragraph 15 Vedanta Limited case, then Session case in paragraph 17, and the court in paragraph 19 has noted the section 36 as it stood prior to amendment and then after the amendment. Then para 20, the court has relied on the Hindustan Construction Company Limited, your lordship. Paragraph 33 to state that this was the observation of Justice Nariman, that he said that he expressed his opinion on the question of the automatic stay, but ratio of the case was something different, which I will take to your lordship. This is a clarificatory things which has come. Paragraph 33. To state that an award when challenged under section 34 becomes unexecutable merely by virtue of such challenge being made because of the language of section 36 is plainly incorrect. As has been pointed out herein above, section 36 was enacted for a different purpose. When read with section 35, all that section 36 states is that enforcement of a final award will be under the CPC and in the same manner as if there was a decree of the court. In fact, this is how section 36 has been read by a 3-judge bench in Lila Hotel so-and-so. Then they are quoting para 45. Then your lordship, paragraph 34, the court has referred to read section 36 as inferring something negative namely that where the time for making the application under section has expired, the award being treated as a decree. These are the observations, Your Lordship. Then, after quoting this para 30, 33, 34, 35, the court comes finally to the conclusion at paragraph 21. Paragraph 21, Your Lordship, I have given the corrected copy of paragraph 21. In view of the settled position of law as laid down in the Hindustan Construction Company Limited versus Union of India 2020, 17 SCC 324, this court is of the considered view that there is no impediment to proceed with the execution. The objection raised by the judgment debtor is therefore not maintainable. The learned court below, Your Lordship, what was the settled position of law was not the observation of the apex court in the case of HCC.
That's the HCC case?
I'll take to you, Lord. Yes. Now, in HCC 2020, 17 SCC 324. 324.
Yes. See, whether this judgment removes the basis of the Kochi case.
Yes, Lordship.
It upholds the Kochi case, my lord.
No, please let me finish. Yes, you have an opportunity. Yes. Your Lordship will come to paragraph 66 of the HCC judgment, which is the ratio of the case. Paragraph 66. And Your Lordship is aware that in HCC case, it was the amendment, 2019 amendment, which came into challenge before the apex court in Hindustan Construction Company's case. Then after these observations which were made by Justice Nariman, and he is the author of the judgment, and he is also the author of the Kochi cricket case, then in paragraph 66 he is laid down the law. Yes. That the result is that Kochi cricket judgment will therefore continue to apply so as to make applicable the statutory amendment made by the 2015 Amendment Act to all courts proceedings initiated after 2310. So, Your Lordship,
yes,
the result of what was the result of these observations? The result is spelled out in paragraph 66, wherein they affirm that what will be the position. If question was posed that if you set aside this amendment 2019, then what will happen? Whether it will be prospective or retrospective in nature. The court answered, the result is that Kochi cricket judgment will therefore continue to apply so as to make the statutory amendment made by the 2015 Amendment Act.
Salutary. Salutary, not statutory.
Statutory.
Salutary.
Yes, Lordship, I'm sorry.
Yes.
Applicable, initiated after 23/10/2000.
Yes.
This findings, this ratio of the case was followed by 3-judge bench. Your Lordship will take Vedanta Limited case 2020-10 SCC. 2020-10 SCC.
Page?
Page 1.
But if I'm permitted, can I make one submission to make it easier for the court?
Yes.
I'm agreeing with the learned senior that BCCI applies. So showing judgments that BCCI is followed, there is no dispute between us. Only thing is, what does BCCI say?
Okay.
Yes, that's it.
Yes, Mr. Jindal.
Yes. Lordship, this is a 3-judge bench judgment, and I am referring paragraph 110. In Hindustan Construction Company Limited versus Union of India, the Supreme Court struck down Section 87 of the Amendment Act and restored Section 26 of the 2016 Amendment to the statute book. It was held in para 66. The result is that BCCI judgment will continue to uphold the field. Hold the field. 3-judge bench judgments subsequently confirmed paragraph 66 of the Hindustan Construction Company. This is the settled position of law.
Yes.
That Amendment Act is prospective in nature, and learned court has committed a grave error in holding that the settled position of law is Hindustan Construction Company and not paragraph 34-35, but those were the clarificatory or observations. According to the learned judge, who is the Justice Nariman, he said that the concept of automatic stay is bad in law. Bad in law. But this observation in paragraph 66, he says, would apply only after the 2015 Amendment Act came into force, and not prior to that. Not prior to that.
Okay.
So, finding of the learned trial court, holding that my objection is not maintainable, is in utter disregard of the settled position of law. And it has caused a miscarriage of justice and set out a bad precedent for the other cases as well, Your Lordship. So, yes. Lordship interference is needed so as to uphold the law. And one more judgment, Your Lordship, I would like to give it. 2023 1 SCC 726. Your Lordship will see paragraph 7.
2003.
23.
The list you've given 2003.
2023, volume 1.
Do you have a copy of that judgment with you?
Only one
Ready?
copy is there. I thought it's not there. 2023.
No, it was mistyped, I think. You showed to them.
Which one you have given? By mistake they have written 2003. Anyway, I'll pass on this to Your Lordship and we'll have a look. In the meanwhile, they will bring the book.
Yes.
Paragraph 7. Last.
Yes.
That rights of the parties are crystallized on the date when the cause of action arose and the law prevailing at that time. Paragraph 7.
23 or 23 or 2003?
2023.
I think this is 2003.
3.
2003. It's a mines and minerals matter.
Yes.
Big Raj Singh. So that's the correct citation.
It is.
Very good, man.
I'm sorry. I'm sorry, Your Lordship.
Nothing to be sorry about. We all make mistakes. Yes. Yes.
Just give me.
Para 7, what does it say?
I'm sorry, Your Lordship. I read it to 2023.
Para 7 is a concluding paragraph. What do you want to show with this paragraph, Mr. Jindal?
I want to show Your Lordship. Having heard the learned counsel for the petitioner, as also the learned counsel for the state and the private respondent, we are satisfied
In
that
the book is
petition.
para 6. Just keep that in mind.
Lordship.
That is para 7 is a concluding. If you take it from the journal, it's paragraph 6, not para 7. Yes, please continue.
The ordinary rule of litigation is that, this one, Your Lordship, I want to show. The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation, and the right to relief should be decided by reference to the date on which the petitioner entered the portals of the court, Your Lordship. That was when I filed section 34 application.
Yes.
Application. Now, had this application been decided within a year or two, there was no question of HCC coming into picture. HCC judgment, Your Lordship, was passed in 2019, and they filed the execution petitions in December 22.
Yes.
And telling that according to HCC judgment, they are entitled to have the execution under the amended section 36, Your Lordship.
Yes.
So this order, Your Lordship, calls for interference.
That's
And
one order. The next order?
Next order, Your Lordship, is the order rejecting our application for
186.
Your Lordship, the second point he will do. I am having little problem. He will do it.
You're not feeling well?
I'm little bit pressure is high. He will do it.
Is that all right?
It's okay, no problem.
You take care of yourself.
He knows better than me.
Lordship, my senior is very kind, but not very prepared. But nevertheless, my lord, the second order in question, my lord, is that page.
You can go to the doctors there. You can get it measured and you can relax for a bit. Yes.
Second order, my lord, is at page 186.
Right. 3523.
Yes.
Yes.
Now, this order, my lord, arises out of a petition that we had filed seeking stay of the execution process that had been initiated in 2000.
Now you've come against two orders by one revision application.
Because one flows into the other, my lord. Because
rather that will be something which you'll have to.
If I can just satisfy. Lordship, I appreciate the point.
Satisfy this court that that is against two orders you have come by way of one.
I appreciate the point. If I can just clarify on that, touch upon that. They filed an execution petition. First, against that execution, we raised an issue of maintainability.
Right? That
maintainability was decided against us by the first order.
Right. So why didn't you come in revision against this first order itself? Because it was passed on 15th of March.
15th of March,
and the second subsequent order was passed on 30th of May.
Yes, madam.
So what prevented you from knowing that the logical flow of the matter will be that the execution proceedings will commence?
Lordship, because
what prevented you from coming at the point of time? You're not talking about one day or the day after that order has been passed.
Lordship,
we're talking about a considerable period of 2.5 months.
Lordship is right. What had happened at that time? What had happened at that time is that parties were in the midst of final hearing of these 34 application. So in the midst of hearing, our choice at that time was either to challenge the maintainability order, come before this honorable court itself at that point, or on the other hand, the more easy option would have been to get the entire matter heard on merits, 34 matter, and see what the 34 order is. Hearing was concluded in part. but for one reason or the other, it was not finally concluded. So, as on date, the hearing is still ongoing. In fact, it is fixed today also before the Commercial Court. So, at that, to answer Lordship's specific question, why didn't we come at that time? It was a choice, maybe not the best of choice in hindsight, but it was a choice we made that because we are in the midst of final hearing, let us hear the entire, let us dispose of the matter rather than get
okay,
stuck.
that reason is reasonable at that point of time. But now we've come at 227 against 2.
Now
that
we've
is
come.
something. How do you
now
expect
the
this
reason,
court to
now the
like
reason,
to yes.
Lordship, now the reason we've been forced to come before this honourable court is because we asked for stay of the execution process through a formal application. Formal application is there, my lord. That is at page 164. If Lordship kindly looks at page 164. We had, after our maintainability issue had been rejected, on the same day, in fact, on 15/3, we filed a petition for stay. So this is maybe one more reason why we didn't come immediately
This was
before
rejected.
this was finally rejected. Against that rejection, we've been forced to come before this honourable court. Now, the reason for rejecting our stay application, that is in the second impugned order, if Lordship kindly looks at page 187.
Yes.
187, my lord, I will not take up too much time and skip the submissions, etc. Now, 191, my lord, is where the problem is.
Yes.
If Lordship looks at the last portion, my lord. The instant application for stay has been filed after a considerable delay of 7 years. First reason why it has been rejected, considerable delay of 7 years. Lordship, the fact that we filed the stay after 7 years is an inescapable fact. We cannot run away from it. But why did we file it after 7 years? For the simple and the more and the obvious reason.
Because 15/3 because of the 15/3 order.
No, we filed it after 7 years, and we did not file it at any point in the before that was because we were not required to, because the law was in our favor, in the sense that we were vested with a right. We were vested with a right before the amendment of 2015 that of automatic stay. Having approached the court before the 2015 amendment, the right of automatic stay automatically vested in us, and therefore we were not required to file until they raked up the issue in 2022. We challenged the maintainability of their petition. That was rejected. Immediately we had to file a stay petition. So that answers this issue, and with all respect at my disposal, I have to state that this first reason of rejection, considerable delay of 7 years, it is not a reason. Going a little deeper into the matter, Commercial Court would have itself realized why the delay happened. Moving on, my lord, that same page. Further, the judgment debtor has not given any security for the due performance of the decree or what? Second reason. Lordship, on this second reason, that the fact that we have not given any security, etc. Firstly, my lord, may kindly look at the petition again that we have filed, 164. Relevant paragraph 11, that is at page 170, my lord. We have made an averment, a submission in para 11, that is at page 170. We have made an averment, para 11, that the petitioner corporation has got a prima facie case for stay of execution of the award without furnishing any security and balance of convenience, so on and so forth. Our submission averment, subject to what the court decided, was that we were not required to pay, deposit any security. In that respect, the finding of the learned Commercial Court is surprising, because the learned Commercial Court says you have not given any security. With all respect again, we were not asked to give any security. First,
sorry to interject. In this, in the pleadings in your 227 application, have you set out the reasons as to why you are coming as two orders by one application? Have you this continuity of the cause of actions that you've clubbed together?
Yes.
Whether you made any categorical submissions as to why this court will be in a position to decide the matter with
Yes, ma'am.
Without taking them independently.
Lordship, not in so many words, but Lordship, I fall back on cold logic. The fact that the
Cold
order
logic, yes, but whether cold logic will defeat
Lordship, being a
due process.
Lordship, being a 227 matter, my very respectful submission would be that strict rules of pleading would not really.
Of course.
So that being the case,
Doesn't mean that we throw to the winds, every.
No, Lordship was very right.
The basic
Lordship,
fundamentals of procedure.
Lordship was very right in raising this issue. I hope I have managed to convince Lordship on this issue. If required, if Lordship requires, if Lordship allows, we'll file a small affidavit. Or that time.
Cure it.
Lordship, again, I go back to the point that.
Anyway, okay, you continue. Yes, that is just running my mind. So this is voicing it. Yes.
Lordship, the second reason was that we have not given security. My simple response, my respectful response is, were we asked to give security? We were never asked to furnish security. If there was an order to furnish security and we did not furnish security, then definitely this second reason that we did not furnish security would stand. So the second reason also, in my humble submission, is no reason. Moving on, my lord, same line, same portion.
So you say the findings were on non-existent grounds?
Absolutely. If I'm allowed to go further, the judgment debtor has not shown in what manner loss will ensue if the stay is not granted. Lordship, again with respect, this is an unfounded observation because the loss, in my humble submission, is self-evident.
Yes.
The award in question suffers from a lot of infirmities which were placed before the Learned Commercial Court, which the Learned Commercial Court was seized of in the main Section 34 application.
At what stage is Section 34 application? Is it the final stage?
It is at the final stage. In fact, today it is.
So it will be concluded today.
It's on the first.
It's not
be concluded today.
Sorry.
The execution petition for compliance is listed today. They were supposed to file an affidavit of assets before the court. They have not been doing it for 2 months. So it's listed for that today.
Yes.
So I stand corrected. It's not the main 34. So to answer Lordship's question, main 34 is at the final stage of hearing. Loss, we did not state in what way would we suffer loss. Loss, my lord, is self-evident, my lord. Moving on again, in view thereof, this court is not inclined to consider the prayer of the judgment debtor for stay of the proceedings. So, Lordship, if I'm allowed to pause here, nothing about law, nothing about the merits, etc. On unfounded and frankly unreasonable grounds, we've been rejected in the stay, and the ground of rejection becomes even more the absurdity of the ground, if I can use that word, my lord, becomes even more apparent if Lordship goes further. However, in the event the judgment debtor deposits the entire award in court within a period of 1 month, the prayer for stay will be considered. So, on the one hand, Learned Commercial Court says, for unfounded reasons, no stay. On the other hand, you deposit the entire amount, we will consider the stay. Again, with all the respect at my disposal, I have not come across an order which speaks in two tongues, my lord.
Yes.
The decree holder has raised objection. This is not very relevant, my lord. So, so this is the matter as it stands, my lord.
So, one question.
Yes, ma'am.
With which order are you more aggrieved? With the first or second one?
Lordship, if the maintainability is found in our favor, this entire proceeding, the other order becomes.
So, if you see as continuity of the entire process, you look at the entire proceedings that are continuing now.
Yes.
Now, Section 34 applications at the fag end, correct?
Yes.
Now, execution proceedings are going on.
Being pressed. Right.
So, the stay is like of immense importance to you, correct? Yes. So, whatever comes out from 34 application will decide the entire list.
True, my lord.
Then?
True, my lord.
So, which order is more important?
Yes, my lord.
Maintainability or the stay? You can choose between one of them.
If I'm pushed into a corner to make a choice, Lordship, I will have to choose the second order for the reason that if it under normal circumstances, under any other circumstances, if the matter was at a nascent initial stage, I would have pressed on the maintainability issue more. But considering the fact that we are at the last stages, considering the fact that the matter is almost fully, entirely, completely heard, if there is a stay and the court and the parties, especially us, can present, can agitate the matter with a more freer mind, without the sword of the execution hanging over us,
yes,
we'd be more than satisfied, I'm sure. We'd be more than
yes.
satisfied.
Yes.
Your Lordship will see the prima facie merit of the case. Here is an award, Your Lordship, which is they are they want to execute to the tune of 15 crore. Out of these, 3 crore is the principal amount. Well,
we're not going there, Mr. We're not going into the substance of the matter. We are on law points with regard to.
I take back this point.
Yes.
But another point, Your Lordship, very important, which the court has also noticed. Award in question, Your Lordship, nowhere states that NIPCO is to pay this amount.
We're not going there. We're not going there at all.
Your Lordship, unless there is a liability on me.
We're not going there.
No,
we're not going there. You're free to make your submission under Section 34. That is that. What's under challenge there?
Here,
see, out here you're coming under 227 for what? For correcting of some error which is patently illegal.
The order has to specify, Your Lordship, that
whatever is general. I'm sorry, but if you come to 227, that is the point we look at. That's all. We think that how the correctness of the order has come before this court. And you know what are the limitations of 227?
Order itself, Your Lordship, the court has noted over submission. Your Lordship will just give me 1 minute to clarify this point.
Yes.
That the award nowhere states, Your Lordship, that they are executing the award against me. It should be at least against me. There should be one word in the award that NIPCO is liable to pay.
That was not before this court.
No, Your Lordship, that is the problem. That is
what
the
can be a problem? You've come to 227, Mr. General. How many times can this court say it?
Lordship will just...
we will examine, of course. I mean, whatever materials you brought before us, we'll examine. Yes, Mr.
Prasuk, Mr. Jain.
Okay.
This matter has been at this fag end for 6 years now. And I think the only reason now, hopefully it'll get concluded maybe, is because we filed the execution. Otherwise, there were just adjournments happening from the petitioner's side.
Right.
My Lord, the first argument they raised was that the automatic stay that they were vested with continues even after the amendment. They relied on BCCI for it. Unfortunately, the paragraphs they read are not the correct ones, my Lord. There is a finding given by the court. So there is no dispute so far as the fact that before the amendment, there was a deemed stay. Party could file an application, get a formal order also, but there was no requirement to do so because execution could not be filed. My Lord, now BCCI, I'll just show 3 paragraphs. My Lord had read BCCI. Paragraph 50.
1 second.
Yes, my Lord.
Para
58, my Lord.
Yes.
Has it? Yeah.
Yes.
So, my Lord, they refer to section 26. So, 26, not of the Act, this is the Amendment Act. So, the 2015 Amendment Act, section 26, amended section 36 of the Act. So, when they say section 26, they're talking about the amending Act, but my Lord has to consider section 36 for this paragraph. From a reading of section 26 as interpreted by us, it is thus clear that in all cases where section 34 petition is filed after the commencement of the Arbitration Act and an application for stay has been made under section 36 therein will be governed by section 34 as amended and section 36 as substituted. So far as this is concerned, I think they have also argued the same thing, that if after the amendment of section 34 is filed, then 36, the amended section 36 will prevail. Now the court puts a second question. The court says, but what is to happen to section 34 petitions that have been filed before the commencement of the Act? Before the commencement of the Amendment Act, which were governed by the 36 of the old Act. Now that is exactly the question before, my Lord. In fact, this is what was shown to the court. I will just come down, my Lord. My Lord may come to paragraph 62. My Lord has that?
Yes.
So the court cites several laws on the clarificatory nature of 36 and the final finding is on 62. My Lord has that?
Yes.
So just after the judgment is quoted, since it is clear, my Lord has it?
Yes.
since it is clear that the execution of a decree pertains to the realm of procedure and there is no substantive vested right. So they have argued again and again before you that they have a vested right in a judgment debtor to resist execution. Section 36 as substituted would apply even to pending Section 34 applications on the date of commencement of the Amendment Act. So in fact, BCCI has said the exact contrary to what they've been arguing. BCCI says that there is no vested right in you because it's a procedural amendment. If it was a substantial amendment and you had a vested right, yes, it would be prospective. But since it's a procedural amendment, it is always retrospective and you do not have a vested right. My lord, I'll just read one more paragraph, which is paragraph 63. The matter can be looked at from a slightly different angle. Section 36 prior to Amendment Act is only a clog on the right of the decree holder, who cannot execute the award in his favor unless the conditions of this section are met. This does not mean there is a corresponding right in the judgment debtor to stay the execution of such an award. So the court says, even otherwise, this was a clog for the decree holder, not for the judgment debtor. So that is why there can be no question of a vested right. Now, my lord, the final finding on para 75. So Justice Nariman has quoted various judgments. I am not taking my lord to every judgment he is quoted. My lord, the last line of para 75, A, 336 page. My lord has that?
Yes.
We express any, we do not, my lord has it?
Yes.
So we do not express any opinion on the aforesaid conditions since the amendment made to section 34 are not directly before us. So my lord, there are certain arguments that Mr. Jindal had pointed out in the paragraph. So there were various arguments being made before the court regarding, because the 2015 amendment made drastic changes in the act. In 34, the grounds of challenge and everything. So Justice Nariman specifically said that I am not looking at 34 because that is not before us. So I'll just read that paragraph. We do not express any opinion on the aforesaid contention since the amendment made to section 34 are directly not before us. It is enough to state that section 26 of the Amendment Act makes it clear that the Amendment Act as a whole is prospective in nature. Therefore, whether certain provisions are clarificatory, declaratory or procedural, and therefore retrospective is a separate and independent inquiry. So he clarifies that since 34 might be prospective, that's
why it's a salutary.
Exactly.
In the
Absolutely. Yes, my lord. Precisely. Now, my lord, this is BCCI. So this was also held in BCCI. Now, what had happened after that was the government came out with a 2019 amendment, wherein they came up with section 87 to negate this judgment. So can my lord look at section 87 of the act?
Yes.
My lord has it? Should I read?
Yes, 87 one, yes.
So this was the amendment the government came out in 2019 to do exactly this, that this will be prospective, that section 36 will only apply prospectively and not retrospectively. So I'll just read that, my lord. Unless the parties otherwise agree, the amendments made to this act by the Arbitration and Conciliation Act 2015 shall A. not apply to arbitration proceedings commenced before the Amendment Act 2015. B. 2. The court proceedings arising out in relation to such proceedings, irrespective of whether such proceedings are commenced prior to or after the commencement of the Act 2015, only apply to proceedings on or after commencement of the 2015 Act. So this was precisely what they're arguing, and that is what the government came out in 2019. Justice Nariman in HCC looked at the vires of this provision. So my lord, I will just take my lord to paragraph 59 of HCC. My lord had been seeing that. He struck down section 87. He said this cannot be. My findings in BCCI have to be followed.
Yes. Right. Okay. Next.
Can I show the relevant paragraph?
Para?
59, my lord.
Yes.
Yes. So the heading says constitutional challenge to the 2019 Amendment Act. This now sets the stage for the examination of the constitutional validity of the introduction of Section 87 in the Arbitration Act 1996. Now, my lord, may straight away come to paragraph 63. The last sentence, my lord, of para 63.
Yes,
finding. For all these reasons, the deletion of Section 26 of the Amendment Act, together with the insertion of Section 87 in the Arbitration Act by the 2019 amendment, is struck down as being manifestly arbitrary under Article 14 of the Constitution of India. My lord, may look at one more paragraph, which is 66. The result is that, I think they also read it to you, my lord. Yes. The result is that Kochi cricket judgment will therefore continue to apply so as to make applicable the salutary amendments made by the 2015 Amendment Act to all court proceedings initiated after 23rd October 2015. So they have upheld the fact that BCCI says that executions can be filed. My lord, I think this would be my argument for so far as the first order is concerned regarding maintainability, why my petition is maintainable. In fact, the Honorable Learned Judge in para 12 and 13 has recorded exactly these submissions of ours and passed that order. My lord, so far as the second part of the order is concerned, regarding they have not considered that unconditional stay could have been granted, no security has been given. My lord, the Act itself requires that unconditional stay can only be granted if there is allegation of fraud or corruption. Can I read that provision? Yeah, yes, my lord. My lord, has section 36.
Yes.
My lord, subclause 3. This is the proviso, my lord. The second proviso.
Yes.
Provided further that where the court is satisfied that the prima facie case is made out, my lord, has that?
Yes.
So it goes on to say, was induced or affected by fraud or corruption, shall stay the award unconditionally. So they're given a specific basis when an unconditional stay can be granted. Now, my lord, I would like to show. Yes, my lord, yes. Lord, I would like to show, my lord, 3 orders of the Honorable Supreme Court, where the Honorable Supreme Court, there were deposits, conditions of deposit. Actually, my lord, I may read some more part of section 36.
Yes.
My lord, section 36(2), my lord, has that?
Yes. Where an application.
Where an application to set aside the arbitral award has been made in the court under section 34, the filing of the application shall by itself not render the award unenforceable unless the court grants an order of stay.
Yes.
The order of stay of the operation of the arbitral award in accordance with the provisions of subsection 3 on a separate application made for that purpose. Now, my lord, we need to look at subsection 3. Subsection 3 says, upon filing an application under subsection 2, the stay of the operation of the arbitral award, the court, subject to such condition as it may deem fit, grants stay on operation of such award for the reasons to be recorded in writing, provided that the court shall, while considering the application for stay in a case of arbitral award for payment of money, this is the money order, payment of money award, my lord, having due regard to the provisions of stay of money decree under the provisions of CPC.
Yes.
Now, my lord, I would like to show, my lord, 3 orders of the Honorable Supreme Court. My lord, the first would be Toyo Engineering. So these are orders wherein the Honorable...
Your citation.
I will hand over a copy, my lord. Will that be?
Yeah.
Yes.
It's a 1-page order.
Yes, my lord. Is all 3 of them? My lord, has Toyo Engineering.
Yes.
This paragraph 3, my lord.
Yes.
This court has, having repeatedly held that Order 41 Rule 5 principles are to be followed in these cases, we find that largely because public corporations are involved, involved, discretions continue to be exercised not on the principles under Order 41 Rule 5, but only because large amounts exist and government corporations have to pay these amounts under arbitral award. Both these considerations are irrelevant. My lord may come to the last line. Resultantly, my lord has that?
Yes.
We set aside both the orders and require 100% of the awarded amount to be made within a period of 6 weeks from today. The appellants may apply to High Court for withdrawing of the security. My lord, this is the first order. My lord, the second order is of Shri Infrastructure versus Candor Gurgaon. My lord has that?
Yes.
My lord, page 2.
Yes.
There shall be an interim stay of the award subject to petitioner depositing 60% of the amount of the decree. The remaining 40% shall be secured by way of a bank guarantee of the nationalized bank within 8 weeks. The respondent shall be at liberty to withdraw the said amount on furnishing appropriate security. So 100% deposit was sought in this, my lord. Now, my lord, the third order that was shown to the learned trial court is Manish versus Godavari. My lord has that?
Yes. Yes.
My lord, the first sentence, the Bombay High Court has ordered 60% deposit pending the Section 37 appeal. We have passed orders stating that since these are money decrees, there should be a 100% deposit, with the respondent being entitled to withdraw the amount deposited and furnish solvent security to the satisfaction of the High Court. Accordingly, we set aside the impugned order and mandate a 100% deposit to be made within 8 weeks from today. So, my lord, this has been a categorical finding.
And one question: how long does Section 34 application take to be disposed of?
My lord, it has been heard finally 3 times by the predecessor court. No order has been passed. It is now being argued again. They have argued
afresh now.
I have to, because there is the new judge.
I have completed my part. He has also completed half of the things.
No, I've completed 1 claim. There are 4 claims. Yes. The argument is supposed to happen on 2nd. My lord, my only point is this. Today, the learned trial court has simply stated, you deposit the money, I'll consider your stay. She has not given me the right to withdraw it. In fact, this petition, at least so far as the second order is concerned, is premature. Had the court rejected this stay application, deposit is a mandatory condition anyway.
But even but the second order also is contradictory in many ways. It has rejected at the same time allowed.
Well, so there were 2 applications filed. So there were 2 applications filed.
2 applications were filed.
2 separate applications were filed, and that
order.
On record. Yes, my lord. The applications are on record. That order considers 2 applications. One was filed under Section 36 before her in her capacity as a Section 34 court. The other was filed before the executing court.
Okay.
So, my lord, they had sought stay under Section 47. I have another order of the Honorable Supreme Court which says Section 47 application is not maintainable before executing courts. You go in 34 and argue it. Should I place that before my?
No, it's
not required. Yeah. Now, the object is that today the 34 application that is pending before the court, the stay has to be granted only on deposit. The application has not been decided.
What are your submissions on the application against 2 orders?
My lord, I absolutely agree. In fact, that would have been a preliminary submission. But since my lord yourself raised it, I did not deem it appropriate. I did not feel it necessary to stress this point. But they cannot do this. In fact, my lord, the 34 order that they're challenging today has to go in a 37 court. They have filed a 227 petition. So even on legal grounds, a 37 application petition lies, and not a 227 petition, my lord. That would be my submission. They have an alternative remedy under law against the second order, which they have not availed. So a petition.
That's it. Yes. Any reply?
Lordship, only the thing, your lordship, if your lordship. Yes. Lordship, I'm instructed to say that if your lordship permit, we'll just jot down the bullet points and place it, because this seems to be a very pertinent question before this court, and
courts are happy, yes, because that's the thing with regard to that is why I asked the other Mr. General to choose. If you make a choice of which which road you want to, whether it's against the stay or it's against the.
No,
We'll deal it accordingly.
no, even if you go by either order, in both the orders.
Okay, you file your bullet points and we'll give you that liberty at least.
And
by tomorrow?
By Monday, Your Lordship. By Monday.
Okay, by Monday.
By Monday, and records may be required to be examined.
You come on 227, Mr. General. You know the limitations on 227 that.
No, I understand,
we
but
exercise self-restraint. We exercise self-restraint.
Your
The power,
Lordship,
of
power
course.
under 227 is to be examined on the records.
Exactly, but we examine if there's a blatant kind of excess of jurisdiction or that. Anyway, I'm not expressing. I'm not expressing. I'm not expressing anything right now. It's a very interesting case, no doubt.
Because today is again the executing court is going to proceed with the execution.
No, the matter is here. I don't think it'll proceed. Anyway, you also file your bullet points on Monday.
My lord, we don't. I can file it if my lord
You
wants.
file it since they're filing it. Yes.
But my lord, let the executing court continue. It's not maintainable, this petition. My lord has raised a very pertinent point. Maintainability, the law is settled. So far as the second petition is concerned, it has to go before the Section
that
30.
Your Lordship has already
58.
decided in NTPC case that appeal against the interlocutory order is not maintainable under Your Lordship's judgment. Along with Justice Dindo.
In fact, supports my case.
one
This
minute.
order is interlocutory. It should not have been filed.
Yes, that is why 227. And we have made a statement in the petition.
Oh yes, under the Commercial Courts Act. Yes.
Yes, under the Commercial Court Act. So revision is the 227 is the only alternative. And
But
my friend is absolutely.
You file your bullet points. You also do it, Mr. Jain. At least give.
My lord, in
your
fact, my
senior
lord's own
satisfaction.
judgment in HCC, by where my lord upheld
Lordship,
provisions of Order 2629, Mr. Jindal was the
Judgment
response.
passed by this court.
By this court, this HCC's judgment, my lord, where
Right,
CPC
right,
was
right.
upheld. My lord, in fact, Mr. Jindal was on the other side and he argued the very same point my lord is raising today. He, in fact, said that automatic stay does not apply in that case. Paragraph 22 of that order.
I don't remember. Anyway.
I've forgotten about the judgment also. That must be in.
Can I hand over a copy, my lord? once?
Only Lordship will consider that till Monday they will not. Till the final disposal
there is
of
no
this.
maintainability, my lord.
Till the final disposal of this case.
My lord,
This is my humble submission.
Give them that. Give them a concession till Monday. Yes,
my
sir.
lord, the court has not passed an illegal order. It is a completely correct order in a jurisdiction.
Absolutely,
To
but
grant a stay will...
Absolutely fine for the ends of justice. Let them file the bullet points. Let them be satisfied.
For the end of justice, Your Lordship
Yes.
will just
Yes.
till Monday.
My
for
lord,
the-
may not do that, my lord. It will...
It will not continue. Don't worry.
Item number 4.
Just orders. At the conclusion of the
My lord, may
hearing-
not record it in the order. We will inform the judge that my lord.
Yes, sir. Heard at the conclusion of the hearing, Mr. V.K. Jindal, the senior counsel for the petitioner, prays him allowed to file bullet points in support of his matter. Mr. P. Jain similarly allowed to permitted to do the same. List on Tuesday.
My lord will have another hearing on this matter.
No, we have to fix the day of filing bullet points, otherwise they won't file it.
My lord, these are in the form of written submissions before my
Just
lord.
bullet points. I don't want written submissions because written submissions will clog up everything.
Right, so one page.
One page, yes.
Page bullet
Yeah, one-
points.
yes,
My lord may
bullet
reserve the order today.
Yes.
I have argued what needed to be argued if my lord wants.
Okay. Judgment reserved. Bullet points we file by Monday.
Yes, ma'am.
Monday and
They'll
till such
understand.
time. Till such time.
I am making a statement.
No orders on that. It's before this court. Yes. You can make all submissions.
Yes, my lord.
Yes.
Much obliged, my lord. In fact, I took my lord's advice and I went to Sora yesterday.
Okay,
It was
so
a very
hope you enjoyed
beautiful
yourself.
place, my lord.
Great.
Much obliged.
Yes, Mr. Yubin, what is the...
My lord, after
Yes,
filing
yes,
this
agreed.
my lord, yes, my lord. Because after filing this writ petition, my lord, the bid conditions, 29 conditions are there, the clauses are there. 22 out of the 29 clauses has been amended, my lord, by way of an corrigendum, my lord. That happened on 18th of this month. That is the day when I have make a mention before this honorable court. And this happened at night, my lord. This happened at night.
How did it happen at night?
My lord, because the
You were witness
letters,
to it, that they're changing the things at night.
my lord, yes.
Yes.
18th, I mean to say, my lord, 18th when July, this happened. 29 clauses, 22 gets amended, my lord, what does it speaks of, my lord? It clearly speaks of that either this bid was authored to favor the favorites, my lord, or it prima facie shows that this was a defective, my lord. It cannot stand. Still now the most interesting part, my lord, the interesting part, even after amendment of 22 clauses, my lord, still one clause that remains, my lord, and that is a catch. And that is a catch, my lord. And I would show, my lord,
what is the catch?
If that amendment comes, my lord, then for a second also I have no case to stand here, my lord. Now, my lord, that is the experience criteria, my lord. They themselves says in the bid petition, my lord, page 15, my lord. Page 15 in the bid petition, my lord, if my lord sees from the bottom, the fifth column from the bottom, my lord, what it says, my lord.
Where page?
Page 15, my lord.
Of
page
the petition.
15. Yes, my lord, of the petition, my lord.
Yes.
It talks about average annual turnover of the bidder for the 3 years, my lord.
Page 15.
15, my lord.
P2.
P2, my lord. Yes.
Okay.
The column is the fifth from the bottom, my lord.
Yes, minimum.
Minimum average annual turnover.
Okay.
Yes. It talks about a 3 years, my lord. Now, OEM turnover also talks about 3 years, my lord. That next, they say the years of past experience required for same similar service, they talk about 2 years. The 2 years. This itself is as contradictory. Now I will show before.
No, why contradictory? Because they're talking about annual turnover for
annual
the bidder.
Turnover,
And here's a past experience. That means that if you have 420 lakhs average turnover for 3 years and you have 2 years experience, you're eligible.
My lord, kindly come to next, my lord.
Yes.
Now these also they have given exemptions, my lord. They get MES exemption for years of experience. Yes, exemption.
What do you say they are? Original equipment suppliers, MSEs. MSEs are what?
Small enterprise, but there is a statutory provision for.
What is MSE?
Small enterprises, my lord.
Small,
medium
yes.
and small.
So, my lord.
My lord, there is a statutory guidelines by the government of India, my lord, that to promote medium and small enterprises.
Okay, let me continue.
Let me finish, my lord. Now, my lord, page 26, my lord.
Yes.
So all these exemptions comes means what? It means zero experience. They say the turnover of 3 years, experience passed for the same 2 years. Now this exemption means zero experience. Now, my lord, kindly come to page 26, my lord. Page
zero
26.
experience. Okay, that's good.
Page
It opens
26.
the field.
My lord.
Yes, opens the field to everyone.
My lord, the rules says, my lord,
Anyway,
all the equals the experience.
Yes.
My lord. Experience criteria, the bidder or its OEM.
Page 26 where?
Page paragraph 8, my lord, the clause number 8, my lord.
Yes.
It says experience criteria. The bidder or its OEM themselves or through resellers should have regularly manufactured and supplied same or similar category products to any central, state government organization, public company for 2 years before the bid opening date. Copies of relevant contracts to be submitted along with a bid in support of so. So, my lord, here again they are asking for 2 years before the bid date is opened. Now they give in exemptions to this also, my lord. There.
No, what does generic mean?
Patented and generic, my lord, in that sense. Some products are patented, my lord, and some are.
So why generic? So for generic, for experience, for generic, what do you mean by experience criteria for generic? Generic, okay, 7. End user certificate. Wherever bid is existing for any user certificate to buyer, same shall be provided in buyer standard format. Generic up to.
Yes, my lord. Now, my lord.
Now, my lord, there's again a guideline from the government, my lord, that unless it is absolutely necessary, patented products should not be, because the costs are very high.
My lord, now, my lord, what I'm trying to point out also, my lord, this is a dilution of the guidelines, my lord. Of the guideline,
now,
my lord,
one thing, Mr. Jubin, sorry to
my lord.
Stop you here.
Yes, my lord.
You know limitations to challenging a clause of tender.
Yes, my lord. Exactly.
You know that the person who owns the contract, owns the work, has liberty to prescribe certain clauses.
Exactly. That is there.
Now, if the clauses are so offensive as on, if you see that it's patently illegal on the face of the record, where it violates Article 14 something,
exactly,
then yes, maybe you might ask for change. But if if you cannot show
my lord,
that these clauses are so offensive
yes,
as to shock your conscience something,
yes,
then you go ahead and participate on the terms that are there.
My lord,
afterwards you can see what
my lord,
as of now you see these are you agree with any of the corrigendum that were made with regard to the alterations? Are you agree with those, with any of those?
My lord,
are you agree with the
alterations, my lord?
Listen, Mr. Human, how many corrections were done to the
those
to the bid conditions?
22 alterations will not make any sense as long as this experience is in place, my lord. Those will not make any sense, my lord. And my lord, may I place the guidelines, my lord? 3 guidelines are there, my lord. May I place? These are complete dilution.
Tenders are totally different thing from after you submitted your bids and your rejection.
My lord,
yes, see.
My lord, this is the guidelines issued by the Central Vigilance Commission, my lord. My lord, kindly look at page number 3, my lord. Page number 3. Page number 3. For civil, my lord has got.
Yes.
For civil electrical works, my lord, it talks about average annual financial turnover during the last 3 years ending 31st March of the previous financial year should be at least 30% of the estimated cost. Number 2 is important, my lord. Experience of having successfully completed similar works during the last 7 years ending last day of the month previous to 1 month in which application are invited should be either of the following. 3 similar completed works costing not less than so and so.
How does that conflict with your clause that years of past experience required? How does it conflict? You're talking about the number of years. Suppose there's no years prescribed and this certain entity, a medium small scale industry, has done 10 works in the space of 1 month. Will that debar them just because you don't have 2 years experience?
My lord, may
the question is, look, what does CVC says? It says that, look, average annual turnover during the last 3 years. That's satisfied, right?
Yes.
Experience of having successfully completed similar work during the last 7 years.
7 years.
Then 7 years.
My lord.
Ending last year a month previous to the one which applicants are invited.
No.
Suppose he's done 10 works in 1 month.
My lord.
Successfully. Will that debar him?
My lord, that may not debar him, but my lord, kindly look at this, kindly consider the corona period, my lord. The conditions that they said with the past 2 years
corona
of experience.
Period? Where is the corona period given clause there?
No, not corona period. I'm submitting that, you know, those 2 years, my lord. 2 years of the corona period, no work was done.
How
minus that means zero experience, my lord.
Mr. Yubin.
My lord, kindly look at the other. My lord,
there's a judgment. There's some judgment.
Lord,
I think passed into. I forgot about it. Challenging clauses of tender.
My lord, the Michigan rubber, my lord.
No, anyway, let him complete.
My lord, may kindly look at the defense and RD organization DRO procurement manual also, my lord.
Don't try to convince me also.
My lord, kindly look. This is the Defense R&D Organization's procurement manual of 2020, my lord.
Yes.
Kindly look at the last page, my lord. For further details, CVC guidelines on pre-qualification criteria issued by OM number so and so as amended available on CVC website will be referred. So I have just referred that one, my lord. So my lord, pre-qualification, it has to be adhered to the CVC guidelines.
Show me how show the court how this has violated the CVC guidelines.
My lord,
show it.
My lord, the CVC guidelines says 7 years of experience.
No.
My lord, says.
No, read it. Where does it say? It says that, see, please.
It says, well, experience
having successfully completed some during last 7 years.
Ending
last day of month previous to the one in which applicant invited should be either of the following. That means not that you done a work 20 years ago and you bring experience certificate. They're just giving the timeline that during the last 7 years, you should have completed these kind of works. And if an entity has completed some work maybe in the last 2 years or last 1 year, they should bar them. That they should be like for 7 years, like starting from year 7, year 1, 2, 3, 7, should do this continuous contracts. No, I don't think that it portrays that.
My lord, now the question here is, my lord, what is the subject matter of the contract, my lord, the tender, my lord. The tender is an instrument. It not only on supply, my lord, installation, training, and maintenance of gadgets, my lord, of an instrument that protects lightning, my lord, and that means that there is a risk factor. Therefore, my lord, an expertise needs to be called in, my lord. The expertise who have got well knowledge in this. I'm not saying that I am there, my lord, for the past several years supporting. Not necessarily that I must get the tender. I'm not saying that, my lord. But what I'm saying is, my lord, the guidelines, my lord, the manual, the procurement, the Ministry of Finance has also passed one circular, my lord. And this, my lord, in this circular, my lord, let's just place this circular, my lord. In this,
you have to show one thing. You remember,
yes,
Mr. Yobin, that you have to show that the clauses are absolutely arbitrary.
Well, I'm trying, my lord, because
yes, you should
because now, my lord, if this clause of 2 years of experience, as I said, my lord, if it goes, my lord, let a competition be a fair competition, my lord. Because once these 2 years is there, my lord, the fairness in competition is going to go for a toss, my lord.
If the 2 years goes,
my lord, if the 2 years goes, my lord, there will be a fair, my lord.
Yes.
Now, my lord, kindly come to the second page, the second one, the second page, my lord. The second page, pre-qualification bidding, PQB, my lord.
Okay.
What is it? In complex technical requirements. In complex technical requirements where capability of source of supply is crucial for the successful performance of the contract, besides considering techno-commercial suitability, it is necessary to ensure that competition is only among bidders who, with requisite capabilities matching the challenges of the task. In case bidders with inadequate capability are allowed to compete, the better qualified bidders would be eliminated, since their bid price is likely to be higher commensurate with their higher capabilities infrastructure. Such situations, a separate stage of PQB bidding system which may be considered, So what I want to impress upon, my lord, is that now, why would, when all the other 22 criteria, 22 the conditions, the clauses can be changed, why not this particular clause can be changed? Now, what is happening? By doing this, my lord, by doing this, as I said, my lord, they are trying to favor the favorites only, nothing else, my lord.
How do you feel favorites? We see no experience required.
Somebody who does now.
Who doesn't have experience is entering the fray.
They are asking. They are saying that turnover of 3 years, turnover in OEM turnover of 3 years. You are saying experience is similar to past 2 years, and you are reducing again down there. You are saying you are reducing the experience, making it 0. So where would be the fairness of the competitions, my lord?
No, that is turnover for 3 years. Experience is different. Turnover is different.
My lord, when a person who does not have an experience, how would we expect for a turnover? A person who is a fresh player, my lord.
Then they'll be weeded out.
My lord,
yes, Dr. Mozika. You have to show that why are these conditions being tossed around like this? I mean, on what basis?
My lord, we received some representations, my lord.
On what basis?
Manipur visit, my lord, we found that because of
forget Manipur visit. What about it's understandable, because that day, the last time of arguments was that there are 2 clauses which are offensive. One is that the product should be sourced from Turkey only. And then that
was absolutely incorrect submission, my lord.
Turkey, and you can't buy equipment from Turkey or China. And number 2, that you have to go to Manipur.
From Turkey, my lord. The requirement was that particular equipment should be tested in that laboratory in Turkey, because that is supposed to be one of the best labs, my lord. But now we have relaxed that if somebody is agreed with that, but tested from any accredited international laboratory or Indian laboratory, my lord. We have relaxed to that extent also, my lord. Now, my lord, lawsuit will see.
Why 22 clauses have you?
My lord, those are very minor changes, my lord.
So why, when in the initial period when the bid was floated, why were these considerations not taken into account?
My lord, maybe when the tender was framed, my lord, the Manipur situation.
Because the
may not have been
only
that
ground
different.
for interference also, one of the grounds for interference in this tender clauses, if it is tailor-made or,
Well,
it is slanted in such a way to favor certain
My lord,
bidders.
I'll point out, my lord.
If this is not that,
My lord, I'll point out, my lord, my friend has submitted, my lord, in government there are 3 types of contracts, my lord. One is works contract, where some civil construction or some kind of construction, my lord. My lord, those tenders are floated through eprocure.gov.in, my lord. Specialized platform for that, my lord. For purchases, my lord. That is GEM portal, my lord.
we are aware of that, yes, we are subject to that same.
Now, my lord, this tender has been floated in GEM portal, my lord, which means that this is not a construction contract, my lord. This is simply a procurement and installation contract, my lord. So, and my friend has cited the CVC guideline which are pertaining to construction contract, my lord. My lord, construction contract are altogether a different kettle of fish, my lord, as compared to supply contract, my lord. So there the criteria are let down the 7 years, 30%, 40%. But when it comes to a purchase contract, my lord, the requirement are different. And I'll point out, my lord, in at least 3 examples that we have been maintaining the uniform criteria, my lord. I'll point out that, my lord. The 2 years experience, my lord.
Yes.
So, my lord, in purchase contract, what Assam Rifles have been following, my lord, I'll place this on record, my lord, that turnover criteria.
When is the bid to be opened, or when is the last date for submission of bids?
31st, my lord.
31st?
31st. It was 21st, my lord.
What about your
and they have submitted a
grievance?
my lord.
You have submitted your grievance.
My lord, we have submitted our grievance yesterday, my lord. Yesterday, my lord. Now, my lord, but then in my humble submissions,
31st coming up, we'll hear it on Tuesday.
My lord, let them file a small affidavit.
No, file affidavit.
My lord, what I am praying, this matter can be closed, my lord. Their representation, whatever they have submitted, that will be addressed to them, my lord. If they are still agreed with that, they can come back.
Yes, we can come before 31st.
My lord.
But when can you dispose of representation?
We have a time limit of 4 days.
See, Mr. Yubin,
my lord,
that it is in public interest also that that we can't stall. We can't stall the bidding or pass any interim orders at this stage, or any interim orders warranted also.
My lord.
That so you have to take that into consideration.
My lord.
We have the window till 31st.
Yes, my lord.
You finish the representation before by today is the.
Today is 20th.
Yes, by the 25th. By Monday they'll give you an answer. If you agree, you can still come back.
My lord. My lord, with that liberty.
That'll be better.
This matter can be closed, my lord.
Yes. Yes. It'll be better. Otherwise.
Just
yes, please.
No, see, Lordship.
Not more than 2 minutes. Yes.
Not more than 2 minutes, Lordship.
Yes.
The only thing is why this clause has been diluted. My only contention before this honorable court is that all administrative powers which are quasi-judicials are under the review of this honorable court.
Of course. Yes.
Please, Lordship. For the last 23 years, such type of work, it has 5 stages. They are only considering the seller and reseller. They are preferring not the manufacturer, but only the seller. They are getting I have got the Turkey reports also. These are all baseless, Lordship. Turkey products are in India with Turkish this METU certification. METU means Middle East Technical University. All products which are going to be installed there are the Turkish product which are coming to India with Turkish certificate. It is under the certification. Now our need is, if I go for this bid, my certificates are to be testified, my product are to be testified from METU. I have approached CPRI, Central Power Research Institute, India, Pune. They have also referred this thing that the Turkey's certification is completely fake. Now, only 5 stages are there First is installment of the product. Second is maintainability. Third is training to the officers regarding the maintainability and use of those products. Fourth is again rechanging of the product if it doesn't work within 2 days. All this categorically to be diluted under those 29 terms, Lordship, by this 22 changes. The only condition is that they are favoring their one bidder who has no experience and the bid will go to him. This clause for the last 2 years under the pandemic of corona, no such work has been taken. So this counted, I say, make it 2 years, but corona period should be excluded. He will be out. We are to provide the best of best product and competition amongst the competitor.
Okay, yes.
Final, Lordship. Please, Lordship.
Take down. No question. The writ petitioner company being aggrieved with the clauses in the bid documents that was floated in the GEM portal on 27/6/2023 is before this court with a complaint that the carrying forward of the bid as per the clauses therein will result in an unfair selection process. Stop. Next paragraph, where the matter was taken up on, when was the last date? Day before? Yesterday?
Yes. 20th.
It was taken up yesterday.
It was 19th.
19th is was yesterday, 20th today. Yesterday it was
When the
mentioned.
matter was taken up on
19th.
19 July 2023, the learned senior counsel for the respondents, learned senior counsel for the respondents submitted that certain changes in the clauses had been incorporated by a corrigendum dated 18 July 2023. Stop. In view of this development, the matter was refixed today for consideration. Stop. In the course of hearing, it has been apprised that the date for last date for submission.
Experience criteria.
No. Last date for submission of the bids is on 31st.
Extended time.
Yeah.
31st July, on the time being extended in view of the corrigendum. Stop. Is the learned DGI further taken this court where the clause for redressal?
Last paragraph.
Yes,
Last
taken
clause.
this court to the clause contained in the corrigendum that if any seller has any objection, grievance against these additional clauses or otherwise on any aspect of this, they can raise representation against the same by using the representation window in the bid details. Further, it is noted that the buyer, in this case the respondents, is bound to reply to such representation and would not be allowed to open the bids if he fails to reply to such representations. Stop. Next paragraph. Mr. P. Yobin with so and so submits that after the corrigendum had been received, they have since filed a representation which is yet to be considered. Next paragraph. Considering that the date of the submission of bids is 31st March, this court deems it fit to close this writ petition at this stage to await the outcome of the representation. Stop. It is made clear that the said representation shall be disposed of by Monday the 24th to enable the writ petitioners to take further course in accordance with law if the need so arises. The calling writ petition stands closed and disposed of. Yes.
Second call.
Obliged, Lordship.
Second call, item number 1.
Ashok, please. What is this?
This matter, my lord, the petitioner was linked of Maukirda like in Nobos of same, my lord.
What do you agree with?
One agreed with, my lord, a SOCOS notice was issued to me. My lord, the SOCOS notice, your lordship will find it as page 20, my lord.
Page 20?
Page 20, my lord.
20?
20, my lord, annexure 2.
One second. Yes.
This was a notice issued to me, my lord, by the same. It says, in connection with the subject and reference above, the chief and Darbar, upon examination of the documents in relation to the instant matter, hereby instructs you to appear on 17th May so and so. So I simply asked to appear, my lord, and your lordship will see a reference is letter number nil dated 17th May 2023, my lord. My lord, this or letter your lordship will find at the next page, my lord.
17 May, okay. Yes.
Now, this is a complaint written by one Bishtan Paliyar, my lord, who does not belong to the clan in question, my lord. Now, he writes to the chief, my lord, with reference to the subject above, I, the undersigned, would like to inform you that the chief, that Sri's petitioner, my lord, as the Lingdo has wantonly cut down trees and burnt the forest within the right rear Lingdo, thereby disobeying the order dated 12/8/22 passed by the Honorable High Court of Meghalaya and CRP number so and so. I am in receipt of another letter number so and so dated 20th March 23 from Maukirwat police station, by which I came to learn that the petitioner had auctioned the Dolun market, ignoring the fact that the case is still pending. The action on this part is also illegal and in violation of order dated so and so passed by the Honorable High Court.
What order is this?
Well, this order I have annexed, my lord. This is at
status quo order, my lord, passed by lordship.
Passed by lordship, simply granting a status quo, my lord.
Where is that? Page?
That's on page 51, my lord.
51.
What happened after this? What happened after this? After 12/8/2022?
Matter appears to be still pending.
Matter is still pending, my lord.
Pending, but then the thing is that in the meantime,
Status quo as to land shall be maintained by both parties.
then what's the matter listed next?
My lord, here your lordship was kind enough to grant us some time to both the parties to settle the matter amicably.
Then what happened?
In the meantime, my lord, but then the petition has been suspended on the post of Lungda. So the term of settlement is kept in hold.
So what, have you instituted some, you're for the same?
No, my lord, I'm for the caveat, the beneficiary respondent number 2, as well as for the respondent number 3, the complainant.
Well,
then
here,
you should notice, sir.
My lord, here, my lord, I've not handed over charge. My lord, the clan is totally with me, my lord. I'll just point out what is the stand of the clan, my lord.
You are number 2?
For 2 and 3, my lord.
Who are you?
My lord, 2, I am the acting Lingdo, my lord.
And
After the
3 is,
suspension of the petitioner, my lord, I have been.
so complaint was
appointed-
filed by number 4,
Number
by number
three.
3.
Number 3, my lord.
And then you appointed as acting link door.
As an acting link door.
There's collusion between the complainant and
No,
the
there's no such
and the person who's incumbent occupying
Now,
office.
kindly see the caveat, my lord. We have annexed the
It's only
caveat
for
which they
extreme
filed, my lord. They filed a joint caveat, my lord.
Oh. We filed joint caveat also.
My lord.
See, someone have to read through the lines in these kind of matters.
I'll address the issue.
So you have a partnership going. Correct? You have a partnership going, I mean, between the complainant and the
joint
venture. So how were you chosen then?
Well, this is only for interim measures.
No, how was the relationship with
My lord, clan.
We belong to the same clan, my lord.
Well, clan is against him, my lord.
clan is no. What is you? Number 2 is member of the clan.
My lord.
Number 3 is not.
He also is part of the clan members, my lord.
He is not, my lord.
But
The
this
complainant
is
is
the
not.
my
my
lord is senior, but this issue has already been decided by the Lord trial court. This is an arbitrary position, my lord, that I am not a member of the clan.
My lord, page 44, lots of kindly see, my lord.
Page 44.
44.
Yes.
But this is written by the clan members to the CM, my lord. With reference to the subject above, the undersigned hereby informed that the Darbar of Palyar Makurda clan in its meeting dated so and so 8 July has resolved that not to allow Paivarul Palyar to act as and function as the lingdo of the clan and land relingdo of the Palyar Makurda clan, which includes Umdolun market land, forest.
Now only one question, Mr. Sangma. Now suppose an acting should be appointed as a concern of the clan we have to take into account.
No, my lord, here what has happened is that since the petitioner has been suspended and the inquiry is still pending against him. Now, my lord, I have been appointed as an interim.
No. What I want to know is about the custom there. Now the clan says that at least if an acting is appointed, they should know about it. Now they are opposing it, saying that we don't recognize him, and we're not electing him. It was an acting link to also.
Now, my lord, this will come only after the findings. Only once after the inquiry has been conducted. If my lord, if there's nothing against him, then
What
he will be
about
received.
what about inquiry? Have you done any inquiry?
My lord, no inquiry, my lord. My lord, more interesting, my lord. If lordships kindly see the impugned order at page 24, my lord. Here they refer to 2 complaints, my lord. NH 3, page 24.
Yes.
Matter pertaining to so and so. The matter has come up pursuant to the receipts of complaint dated 17/5 and 21/6. I don't even know what is this complaint, my lord. Never given to me, my lord. Filed by Briston Palyar of Lang Mapra village, so and so.
That's number 3.
My lord, so, my lord, there is a reference to 2 complaints, my lord.
Are there 2 complaints, Mr. Sangma?
My lord, yes.
There are 2 complaints.
My lord, the second complaint is the additional complaint in pursuance of the first complaint, in reference to the first complaint. I'll place it out, my lord, the order.
Moreover, my lord, our stand, my lord, if I was given an opportunity of hearing, my lord, I will satisfy the 3 allegations, my lord, of the by the complainant, my lord.
But that will come to course of inquiry.
That will come in the course of, but my submission is, my lord, without there has been no hearing given to me, my lord. If that was given to me, I will very easily, I'm confident that I'll satisfy the CM that I have not done anything wrong, my lord.
But you see, one thing is that Mr. Sangma, which is disturbing, is that it's just a blanket suspension. It's like a removal. It is not a question. It's not a question like suspended pending inquiry or something.
It is pending inquiry.
Where does it say?
If we take my lordship to the.
See, I'm reading this. It is read the 72. I'm reading the Khasi version. It's until other orders are issued with notification.
If I might take your lordship to page 72A.
Yes, 72A.
My lord. If I may read. The chief and Darbar nobles of our same ship do hereby notify the same ship and Palyar Maukota like clan that as per the order number so and so dated 4th July 2023, Sanat number also dated 4 July 2023. The chief and the Dorbar suspended Shri Stopinely Palyar as the Lungda of the Palyar Mokarda like Poglan has appointed the resident of Nongdulan as the acting Lungda of Palyar like Po until further orders. So, my lord, if I may take your lordship to page 26, my lord.
26.
26. The translated copy is at page 24, that's annexure 3. Your lordships have it. When we read the last paragraph, my lord. Therefore, the chief and his Dorbar, upon perusal of the documents filed in this connection, it is found that the allegations have merit, and hence it is decided that Shri Stopinly Palyar be suspended. Last paragraph, page 24. After ground number 3.
Where's the original version of this one?
Well, the original version is at page 26. Khazi version is page 10. You may read now.
Once again. Okay. Yes.
Now, my lord, in the same annexure 3, pertaining to ground number 3, if I may take a lordship to paragraph.
Now, this one, you served this copy for July, Mr. Dr. Mozika. That is number 3, the issued permission executive engineer so and so to implement a project. Can this be an allegation? If this for
my lord, that has been with full approval by the clan, my lord. My lord, we have annexed that document also at page 60, my lord.
Yes. What kind of inquiry do you propose to have? Another thing.
My lord, even the market, my lord,
Mr. Sangma, you have to appear for all 3 of them, I think, because.
No, my lord, only for one, only for 2 and 3.
Page 73. Cavities is the same. Hyberlin Palyar and Bristol Palyar. And page 73.
My lord. I have not filed the instant caveat, my lord. I have not filed the instant caveat.
This caveat, you have not filed it?
No, my lord.
Then who filed? How can it be 2 caveats then?
I have filed the caveat pertaining to this matter, my lord. That's
so this is what? Then what is this you annex, page 73? Very curious case. It smacks of collusion. That's why this court is. That's why this court is concerned.
Page 64, my lord, lordships can see, my lord.
Page
64, my lord.
See,
the caveat.
If it is a pure case of suspension, yes, but it's to. See.
But again, my lord, yes, acted in violation of the status quo order.
Yes, see page 68. Who signed this? Who filed this caveat?
They filed against the.
You didn't file it.
I didn't file, my lord.
Why was this caveat filed before the judge?
It was filed before the district council, my lord.
Something is not right, Mr. Sangma. Something is not right. I mean, why should you file a caveat against the order?
The suit cannot be filed, my lord.
No, and all the three respondents are filed jointly, and now you're here on behalf of 2.
2 and 3.
Yes.
My lord, what I am praying at this stage, my lord, all 3 allegations, my lord, these are not even allegations.
Allegations.
If a chance is given to me, my lord, if a chance to given to me an opportunity of hearing, I'll satisfy the CM, my lord, that there is no violation of any of the directions, my lord. And my lord, in para, I've made a specific government in para 22, my lord, that I'm continuing, my lord. Let them file an affidavit, my lord. In the meantime, a status quo is directed to maintain, my lord.
I'm against this direction of the status quo, my lord. My lord, if you can take your lordship again to annexure 3, pertaining to ground number 3, my lord.
That is page
24.
Page 24, okay.
Your Lord, the ground is that he issued permission to the Executive Engineer MEPDCL Nongstoin Division to implement the project at Maukrang Maupat, which falls within the clan Landry Lungda of Palir Maukota Like Paw. Now, my lord, we take your lordship to page 8 of the writ petition, paragraph 10, my lord.
Page 8.
Page 8.
Yes.
Para 10, my lord. If I may read. That the petitioner states that insofar as the third ground on the basis of which the petition was suspended, the petitioner would again contend that the permission was granted. My lord, the word permission was stated, granted to install the transformer only after a decision in that regard that had been taken by the clan as a whole, and the same is not the unilateral decision of the petitioner. Now, my lord, in this regard, I'd like to place the sale deed executed between the petitioner and the MEP.
No, we're not going to the allegations right now.
Page 60, your lordship kindly see, my lord.
You're going to
this
the
is the clan
procedural
resolution, my lord. Page 60 is the clan resolution.
My lord, this is a clan resolution after the removal of the petitioner.
Page 60, my lord.
We will not go there. Only a very curious case since that all three have gone for his council court to try to, and you also have come for the complainant and for the person who's eating the fruits of that complaint.
The respondent is a mere beneficiary.
He's a beneficiary, yes, enjoying the fruit. So what is this fruit that you're all after?
If we may allow to place on record the second complaint.
Yes.
But it is written in Khasi. I cannot get time to translate this letter.
Regarding the?
This is the regards to the second complaint, my lord. That is the additional complaint.
This would give me a copy of the second complaint also, my lord.
Yes. Take down. The petitioner being aggrieved with the suspension order dated 4th of July 2023 before this court, praying for appropriate orders. Stop. The main grievance is that the entire manner in which the proceedings has been suspended smacks of irregularity and malafide. Firstly, as the copies of the complaint were not made available to him, nor was he allowed to reply to the same. Stop. Mr. CCT Sangma, next paragraph, is present by way of caveat on behalf of the respondents number
2, my lord.
Number 2 only.
Number 2. For number 3, my lord, I'll file my power during the course of the day.
But you file a caveat on
only for.
You said you're appealing for 2
only
and
for
3.
2, my lord, yes. For 3, I'll be filing my power during the course of the day.
As a caveator on behalf of someone 2, and also submits that he will be representing the respondent number 3 in the instant proceedings. A perusal of the materials as placed reflect that the suspension order speaks of suspension order bracket at annexure 3 speaks of 2 complaints dated 17/5/2023 and 21/6/2023 filed by the respondent number 3 against the writ petitioner. Who has the order asking to appear?
Previous page, my lord. Page 20, my lord.
No?
Using of the materials as placed reflects that the suspension order in bracket measure 3 speaks of 2 complaints dated 17/2023 and 21/6/2023 filed with the respondent number 3 against the
Whereas Via a communication to the 10/6/2023, the writ petitioner was directed to appear before the respondent number 1 with regard to the complaint dated 17th May 2023. Further examination also shows that all the 3 respondents had also lodged a caveat before the court of the judge, District Council Court, being apprehensive about the writ petitioner. All the three respondents had jointly filed a caveat before the District Council Court against the writ petitioner in apprehension that the impugn orders would be challenged by way of civil proceedings. The manner in which the respondent has been suspended has raised certain doubts in the minds of the court. Especially with regard to the non-disclosure of complaint and the fact that not only complaint and the fact that have you filed a show cause?
No, my lord.
Have you filed a show cause? Mr. Dr. Moizika?
The appeals were not filed, my lord. But only one very important aspect, my lord, how it happened, my lord. Lordship kindly sees page 22, my lord. This is in Khasi, my lord.
I mean, show cause to what is show cause to 13/4 now? 13/4/2023 is what? Mr. Samo's 13/4/2023.
Page 50.
You kindly come to page section 9, page 52.
Oh, here we are filing.
How many complaints are there, Mr. Sama?
But this is we are filing application before the district council, intimating that since this.
No. How many complaints have you filed?
Only 2.
You see, 2. But then what I've done? You show cause to what? 13/4.
You'll also kindly come to page 50, annexure 8. This is the letter addressed to the Joint Secretary to the Executive Committee, KCTC. This is with regard to the auction of the market Umdalan.
Oh, this is a parallel proceeding. But on the basis of this, you already suspended him. While at the same time you waited for the district council to recall the permission. You've not made them party also.
They never made a party, my lord, with this council.
Very strange case.
My lord, moreover, my lord, very interestingly, my lord, page 22 is the so cause notice issued, my lord.
Yes.
Now, what I understand, my lord, this letter is dated 10th June 2023, my lord.
Yes.
Just below the line, my lord.
Yes.
Then it says Kasiti Nil dated 17th May, my lord. Then it appears that he has been asked to summon on 17th May itself, my lord. Whereas the letter is issued on 10th of June, my lord.
No, something is not right. That's why this court is concerned. Something is not right with the entire episode. Mr. Sama, you have to admit that also. Something is not right. 3 people sat in a room and said remove him and start generating. You asked to reply to 1 show cause, then you said the other 2 complaints.
And 10th June, my lord, how can somebody come and appear on 17th May, my lord?
The same will be a better position, my lord, to address the issue.
Who?
The same will be a better position. The respondent number 1, my lord.
No, it is very. Very disconcerting. Any thought, no? Especially to the correspondence, such as he translated the letter dated 10/6/2023, directing the British to appear on 17 May 2023. Next paragraph. Next one. Issue notice to the respondent number 1. Steps to be taken within 3 days. Stop. Mrs. Heathler, on behalf of respondent 2 and 3, also to file an affidavit within
2 weeks.
Sort it out with them first. In the meantime, status quo as of today should be maintained. The next date. The court is very strange.
Item number 5.
Yes. Number 5. It'll take some time.
No, I was in fact thinking I won't press this application at all. Miss case number 1.
Yes.
The registry has computed based on the Meghalaya Court Fees Act. Maximum court fee at 11,000. The Central Act provides 3,000. So I'm willing to pay that. No orders are necessary. As per the last competition that remains, I'll pay that amount.
Yes, Mr. SN submits that the instant Mrs. application MCFA1 will not be pressed as the registry has computed the maximum court fee which they undertake to pay. Accordingly, MCFA1 of 2022 stands closed and disposed of.
As far as 4 is concerned, my learned senior has filed an objection with regard to my prayer for amendment. If they're not pressing it, then that may be allowed. Else, Lordship will take it up next week for hearing.
You are pressing your objection?
I'm objecting, Your Lordship.
Yes, okay. Then,
That will be taken on Monday.
At the request of the counsel of the party, let's this matter on Tuesday.
Monday, Your Lordship. Monday?
Tuesday.
I'll you pledge.
Tuesday 25th. Yes.
Item number 6.
There was a direction to us to file the scheme of compassionate appointment related to the department concerned. But we filed it by way of an additional affidavit. This was filed.
No, but then the thing is that you have to go before
CAT.
Yes.
But here the only
is available now.
It is available, Malad. Here CAT will be very cumbersome.
Cumbersome doesn't mean the jurisdiction is not there. How will school
financially they are very weak as of now.
Legal aid.
That is up to you, Malad. But here, in any case, Malad, there's no blanket ban on having an alternate remedy. There's no blanket ban on the exercise of jurisdiction or 226, Malad. And as it is, Malad, I'm ready to forego one forum, Malad. I think it is to the detriment of the petitioner here. He's willing to take that risk, Malad.
Then you want to go straight for division bench. You take it for granted that your matter was dismissed.
That is an ultimate decision, Malad. The only problem, Malad, that will of course, Malad, incur some additional expenses which this gentleman, as a matter of fact, this petitioner is unable to bear, Malad.
That is not a consideration.
Malad,
It's a matter of jurisdiction. It's a matter of jurisdiction, Mr. Thapa. Every other person will come and say that we can't go to, to the what do you call it, the appellate tribunal in Calcutta because we are totally our company bankrupt. Then we can't go to the armed forces tribunal because
Malad, having a CAT, Malad, that does not fetters your lordship's power under 226.
You think about it, explain to your client. We'll have it on Monday. You tell them that the court says that you have to, and use your good offices. You have lots of friends in Guwahati. You can take it up free.
No, but I'll do that.
That's part of your duty as a lawyer to society also. Yes. And pay the taxi fare also for them to go.
Main list, item number 1.
Yes.
Please, Lordship. Lordship, I pray that this matter may be taken up after 2 weeks.
In bereavement.
Lordship.
Yes, as the application has been bereavement, it's a matter of 2 weeks.
Item number 2.
Hello, Lodge.
Yes, MSE1, are you ready?
May please, Your Lordship. Your Lordship, we beg this item can be come up after 2 weeks, Your Lordship. My senior's not well, Your Lordship. He's been hospitalized.
Hospitalized?
Yes, Your Lordship.
Okay. As the signing counsel, with the PG Ganta, the senior counsel will be hospitalized. It's just a matter after 2 weeks.
Much obliged, Your Lordship.
3.
Where's the petitioner? Have you filed affidavit of service? Not been filed. Office law indicates that affidavit of service not been filed. So this is a matter after 2 weeks.
4. 4.
I filed an application for striking off, my lord.
Your Lordship, I have to seek instructions, Your Lordship.
Why?
Since the conducting counsel is from Delhi, so.
You've seen Jyoti Basu's judgment, correct?
Yes, Your Lordship.
Then?
Settled law, my lord.
Your Lordship,
Yes.
I am appearing for respondent number 3.
Yes. What do you want?
Your Lordship had granted us 2 weeks to file the application of objections.
Yes.
I am seeking 1 week's further time for filing it because the applicant is out of town. So
You've seen an
we have not been
application
able
for
to
John under
complete the
order
formalities.
17 Rule 1 of CPC for perhaps it was just so stop Mr. Sorry, was it Pandey? Mr. Pandey, right?
Yes.
Yes.
Yes,
Submits that due to the unavailability of the respondent number 3, a week further time be granted to file objections. Prayers allowed. Yes, with regard to the application filed by the respondents 1 and 2 for striking off Mr. So seeks prays that he be allowed to seek time. It's a matter of 2 weeks. Yes. You see, it has settled law. It is not,
Deep.
Item number 5.
Deeply.
My lord, this is an application under Section 5 of the Limitations Act for condonation of delay.
How long the delay?
270 days of delay, my lord. The response have come, my lord. The objections have
You have any objection?
Yes, Your Lordship. We already filed. We filed by way of affidavit, Your Lordship, in compliance with the order passed by this honorable court.
You see that they have not made out any sufficient cause.
Yes, because
they have not made out sufficient cause for delay.
Yes, Your Lordship. They have given wrong and insufficient grounds. I mean, I'd like to draw your kind attention, Your Lordship.
Wrong is different, insufficient is different.
No,
What is the wrong or are they insufficient?
No, wrong and incorrect. Sorry. Wrong and incorrect, Your Lordship. This application, the condonation application, filed by the petitioner, Your Lordship, being the respondent in the London Appellate Court below. I'd just like to draw your kind attention. Their application, Your Lordship. Para 4.
Yes.
Yes. Thereupon, that the petitioner submits that upon the receipt of the summon, he entered as appearing through his counsel, and the counsel on each and every date have raised objections. Each and every date have raised objections on the materiality of the appeal, without an application of condonation. However, this is very important, I'd like to draw your attention. However, the learned judge, District Council Court Shillong, did not consider the objection of the learned counsel regarding whatever objection they wanted to file. Rather, had fixed a date for hearing, therefore. That's very important. I'd like to draw your attention, Your Lordship. The Honorable Court below, Your Lordship, had given ample opportunity for the petitioner to file the application regarding the
maintainability.
But I'll draw it page 15, Your Lordship.
No, I don't understand this. That the petitioner submits that upon receipt of the summon,
yes,
he entered his appearance,
yeah, already
his
appeared.
counsel, and his counsel on each and every date have raised objections to the middle of the appeal without application of coronation delay. I mean, they didn't file coronation for days.
Yes, no. What happened is, my lord,
Listen.
Let me come.
Another judge did not consider objection at a fixed date of hearing.
Yes.
So then fine, the fixed date of hearing for hearing that. What happened?
Hearing of the appeal, my lord. Hearing of the appeal.
Not the hearing of the maintainability.
Yes. No, I think, Your Lordship, with your permission.
We have filed a suit.
Trying to misrepresent the facts, Your Lordship.
Let me just finish, my lord. We have filed a suit.
Because if you have to go by one second, Mr. Walang, if you go by your application,
my lord,
if you go by application coronation delay, is this an application coronation delay? What is sufficient cause? How do you have to make it out? You have to explain each and every day of delay.
Wrong and
my lord,
incorrect.
First, my lord, let me explain, my lord. Let me just, my lord. What happened is that, my lord, when we have filed a suit for recovery proposition and a status quo order before the subordinate district council court at the village.
Material, Your Lordship.
My lord,
in this juncture.
My lord, injunction was passed, my
We're
lord.
not going there.
My lord,
I'm sticking to your coronation application before this court.
Exactly,
now,
my lord.
is this explanation? This is the kind of explanation you have given
Within the ambit,
in para
within the
4.
ambit of this.
Within your term
Yes,
coordination only.
My lord,
Look, as a reasonable, as a reasonable person, human being. Now you read this para 4.
My lord, that is what I'm trying to explain.
Suppose you put yourself, you're explaining to a person why delay has been caused. He doesn't know anything.
Yes.
Now, how do you? Will this suffice?
My lord, now what happened is that, my lord, when we appeared,
when
the summon
does it say anywhere here?
No, my lord, it
I'm
says
talking about
that
your application.
Yeah, exactly,
Where have you
my
said?
lord. My lord, it
Where have you
says
said?
that
Where have you said? Where the dates given that you appeared on so and so date? That every date you appeared. Where have your next order sheets?
Yes.
Where have you said that this order was fixed for hearing, and was not fixed for hearing on the coordination application fixed for hearing appeal? Where's that?
My lord, that I have not annexed. My
Then,
lord,
where you make a bold statement, then you expect 1270 days condemnation?
my lord, let the order, let the records may be called, my lord.
Very good. I mean, you want a court to do the work for you.
No, my lord, let
For you to make a sufficient cause. I'm sorry, Mr. Yubin.
Yes.
my lord, here, my lord, because we are saying that, my lord, we
trying
have
to
said.
mislead this honorable court, Your Lordship.
This is an
Yes, Your
application.
Lord. This Mrs.
Case
application.
number 6, 2023.
CRP number 6 of
No, wait,
2000.
sit down, Mr. Walam. Don't get overexcited.
Yes, sorry.
Yes. A hearing impugn order dated 11/5/2022, passed in Mrs. CA number MCA number 5/2022 by the judge. The delay as made out in the coordination application is for 270 days. Stop. Though courts are generally liberal in granting, in condoning delay, the coordination application by itself does not show any sufficient cause or any reasons attributed as to why delay has been caused. Para 4 and 5 of the application is hereby reproduced. Last one, as no satisfactory explanation is given, no details attached with regard to the cause of delay, this condition application is dismissed, which is without any merit.
My lord, let me withdraw this, my lord, with liberty to file it, my lord, because there's very important question, my lord, that we are raising, my lord. And
You should have thought of that earlier on.
Yes, let it be agitated below.
We'll go back below and argue.
Yes, that's the best.
It's still pending, correct?
It's pending.
Pending.
It's pending. Obliged.
Highly obliged.
This is that matter regarding acquisition of land, my lord. The state respondents were supposed to file affidavit.
You filed affidavit regarding the letter, you filed it.
That we are in the process, my lord.
Then you're putting the blame on them. What do you have to do? You want to file affidavit?
Affidavit is ready.
Yes, petitioner and respondents to file the affidavits as directed by order dated 5/7/2023 within 2 weeks. List on so and so, yes.
7.
May I please, Your Lordship, Your Lordship.
You won't file the joinder?
Not yet filed.
Already filed?
Not yet
Your
filed.
Lordship. The draft is ready, but the signature of the deponent is.
Okay, you'll file it with the course of the day.
No, Your Lordship, 2 weeks' time, Your Lordship.
It's only for signature, 2 weeks' time it needs to sign.
He's not here.
Further 1 week's time is granted to the petitioner to file a joint affidavit. This thereafter and so on.
8. Item number 8.
May I please, Your Lordship? I have received some instruction from the office, Your Lordship. I may place.
Yes.
I may be allowed to place it on
Yes.
record.
You've been paid.
My lord.
Your Lordship,
My lord, as per the instruction yesterday I received from my client, what was happened after filing this instant writ petition, the DI, Subdivisional School Education Officer Dadangri, has deposited 26,450 rupees to the petitioner's account without calculating the entire amount, without calculating what is the amount for the gratuity, what is the amount for the family pension.
it is there, Your Lordship.
And moreover, another aspect, my lord, as per the instruction of the SDSEO to my client, that the petitioner during his lifetime he has overdrawn 2 months' salary, and the petitioner is forced to deposit that amount also to the DI office. That is the case, my lord. They have not calculated, they have not filed any affidavit. So what is the amount? They have suggested for succession certificate. On what amount will go for succession, my lord?
May I please, Your Lordship? Last third page number 3, Your Lordship. It is there
Calculation,
for
you've seen the paper, it's given you.
My lord, just now I have, my lord.
You look at it, this is matter after 1 week. MSS Bharat Leonard J has produced a communication dated 23rd June 2023, wherein the details of the payment paid to the petitioner have been given, especially at page 3 thereof. Stop. Mr. S. Kassan seeks 1 week's time to examine the same. This is the matter after 1 week. Copy of this
Maybe
taken on board, be part of the record, yes.
Look at it. May I please, Your Lordship? One more submission is there. Respondent is ready. If the petitioner approaches the office, they will provide her the details of the account, because, Your Lordship, petitioner died in 2015 and representation was made in 2020 and service
correct.
book, yes, service
So we'll
book.
close this. We'll close the petition then, Mrs.
And now
Kassan.
they are charging for interest, Your Lordship, paying for interest also.
Yes, my lord. We have claim for interest. My lord, we have approached the
instruction
office
after 1 week.
Yes, my lord. We have.
Much obliged.
We'll dispose of next week.
9.
My lord, the pension part they have not mentioned, my lord.
Pension part is
Family
yes,
pension, my lord.
family pension. May I
Family pension.
Next matter.
9.
Highly obliged.
The joint is filed, Mr. Nyuta.
Yes, Your Lordship, I have filed. But Your Lordship, now I'm praying that allow me to file an additional affidavit, Your Lordship, because last week, Your Lordship, there was a funeral, Your Lordship, in the village.
There was a
funeral. So as per the village practice, Your Lordship, one female member of each house has to go to the deceased house for the village work. But when the petitioner, when the in charge was not allotted any work and were not allowed to do any work, stating that the headman has directed not to give any work
to help in the funeral home.
Yes, Your Lordship.
So that's actually
So on the other hand, Your Lordship, is that
carry with that. It's not the duty of the person to say you go and wash the utensil or you go and peel up the
Yes.
nuts.
No. Yes, the joint after it's been filed, but this is matter for hearing. Yes, after 2 weeks. Yes. To peel beetle nuts, you said? Okay.
Work is simply like that.
it was the practice of the village, Your Lordship. But when he was not allowed, it's stating that the headman was not allowed. So regarding
that, you can see when matter of hearing, you can bring it up.
All right.
Item 10.
And you ensure, Mr. Kharshing, that this doesn't happen.
Nothing such happened. My lord, this case it comes into play just because they have filed the title suit because of this only.
Okay, yes.
And we have the prisoner facing this problem because of this title suit, Your Lordship.
Yes. Respondents, no
10.
affidavit number 10.
10.
May I please, Your Lordship? Lordship, I'm praying for 2 weeks' time to file an affidavit on behalf of respondent number 1, 2, and 3.
Room Thao or Pradhan? 4 to 7.
No, my lord, 4 and 5.
But here shows us 4 to 7. 4 to 7 whom? Yes?
It's been wrongly reflected. We are just representing point.
Okay.
We'll take steps, Lordship. 6 and 7.
Yes, it has been informed that though Dr. M. Mozika, DHI, has been shown for response 4 to 7, they in fact appearing for 4 to 5. So, the counsel for the petitioner directed to take steps on the response number 6 and 7. Stop. Next paragraph. How much more time you pray? Prayers also made by response 1 by Salam. We have 1 to 3, and so on. So for 4 to 5 for the 3 weeks time to file affidavits. Prayers allowed just after 3 weeks for affidavits and for service report on 6 and 7.
11.
None of you file affidavits?
Yeah. Even me, I'm praying for some more time to file an affidavit.
What about 6? Yes, Mr. A movement, Vice Mr. S sent for 1 to 3, and Ms. Datta for 5. Praise for the 2 weeks time to file the affidavit. What about number 4? Who's number 4?
It's the Muslim University. I have
appears
taken,
here.
I have taken step, Your Lordship, but I don't know whether the notice has been served or not.
Yes, also after Mr. Philemon Nongri on behalf number 6 submits that as they have no role to play, no affidavit forthcoming from their side. The service report on number 4 has not been received. Stop list after 2 weeks for affidavits and for service report is for number 4.
Right.
12.
May I please, Your Lordship? I need some more time to file the reply, Your Lordship.
5 has been served also. 5 is whom?
The principal.
Office note indicates
Please
that
note the
the service
comment.
is complete on respond number 5. Stop. Next line. MSS for the charge in GA for state response 1 to 4. Praise for
2 weeks.
2 weeks time for the time to get instructions for affidavit. Stop. Next. According to this matter up to 2 weeks for affidavit and for appearance respond number 5.
Item 4. 13 also.
Yes?
13. 13 also.
Same correspondence. Sir, just check that, sir. Number 5 to number 13. Sir. Okay, don't go. Yeah. I will see that.
Hearing item 14.
This is that matter regarding parallel proceeding, my lord, before the DRT and NCLT, my lord.
Yes, Mr. Ganguly.
Mr. Ganguly was supposed to be here, my lord.
Ready for the matter today, correct?
My lord,
You're ready?
Mr. Paul, my lord, is leading in this matter.
Where is he?
But, he actually, my lord, today he is not here, my lord.
He's
He's out of station, my lord.
Where is Mr. Ganguly? There's some urgency in the matter, correct?
Yes, my lord, there was some that.
On your part, on the part of the
on
respondent?
the part of the respondent, my lord.
This is a matter up to 1 week. On the prayer of Mr. M. Chanda, sorry, not
19.
Also not appears for the respondent.
This is regarding the dispute of Nokmashi.
From any urgency?
Urgency too is there, my lord, because my client is bedridden. So it may be taken next week. My lord.
Where's Mr. Day? He's coming.
Yes, Your Lordship is coming.
If it's urgent, then you're ready.
He's on next.
No, no, we'll take it up at 2:15 or something. If you're ready.
Yes, my lord. I am ready, my lord.
You said fast. We're ready. Well, once we take it up, we'll finish it off.
Yes, Your Lordship.
Where's Mr. Day? We'll take it after 2 weeks then.
No, my lord, next week, my lord.
Okay, next week, after 1 week. Yes. If the absence of Mr. S. Day so and so, for response also, it doesn't matter up to 1 week. Yes.
Master.
If they have the ready, if both the sides are ready, we'll take it up at 2:15. Yes.
22.
You ready, Mr. Khan?
My lord, I'm ready, my lord.
Ready? They will have it at 2:15. What's the matter about?
Your Lordship,
This is regarding that librarian, her service was terminated, my lord.
New has
In that
been-
case, my lord, it can be fixed some other time also, no problem, after a week.
There's no urgency.
No, my lord.
Urgent matters will take up. This matter will be on the prayer of council.
Obliged, my lord.
23.
May it please Your Lordship, we will be filing the additional affidavit during the course of the day, Your Lordship.
Bring your appointment orders.
Yes, Your Lordship.
MSD and Marak
Yes, Your Lordship.
submits the affidavit to trigger the additional affidavit as allowed by this court. Will be filed in the course of the day. Just after 2 weeks.
2 weeks, my lord.
Let's check. 24 and 26.
24 and 26.
Similar.
The list together with 24 and 26.
All right.
27.
Yes, the chai, I've been waiting for very long.
No, my lord.
This is with regards to that.
Your Lordship, if this matter can come next week, as Mr.
Why?
Senior is not feeling well, he left, Your Lordship.
Yes, as the senior arguing counsel for respondents 2 and 3 not available, doesn't this matter after?
Next week, Your Lordship.
Not next week. It will be after 1 week.
Sorry. Much obliged, Your Lordship.
29.
Please, Your Lordship, I pray for some accommodation in this matter, my Lord.
So you'll make Mr. Jahagu empty-handed back home.
No, can't help it without respondent, my lord. This is with regards to, my lord, that grant of disability pension.
Hello, yeah? Yes, on the prayer of some, so the absence of unavailability of the DHGI, this is a matter up to 1 week. Yes. So.
Much obliged.